opening remarks from the various witnesses. Each witness will be provided 5 minutes. When you're cutting it when you're very close, and I just want to indicate you should be wrapping up your comments, I will hold this up. And that applies not only to your opening remarks where you get 5 minutes, but also when the members are asking you questions. So that all having been explained, I will now go to Mr. Bellissimo, who is joining us virtually. Mr. Bellissimo, the floor is yours. You have 5 minutes.
Good morning. Thank you, Mr. Chair, members of the committee. Thank you for the invitation. In our brief submitted before the Senate last year, we made 5 recommendations, which we repeat here. We endorse the concerns highlighted by the CBA and the Refugee Center. So why our recommendation? Context is always important. The current law is potent. As the committee knows, the authority to render individuals inadmissible under the IRPA for international and human rights sanctions has been in place for over 20 years. Of the thousands of people currently on the sanctions list, we cannot identify anyone that would currently be inadmissible under Canadian immigration law. But what's the harm in adding more sanctions? The bad actors should have no access to Canada. We agree. Yet it is much more complicated. The IRPA's jurisdictional integrity, for one, is at stake. Why? Aligning all of Section 4, 1.1 of the CIMA with the IRPA introduces, just to list a few, economic sanctions, where recommendations to sanction result in automatic inadmissibility, and where investigations into sanctions could be grounds for detention without legal context and without relief from third-party adjudicators like the Immigration Division. That will now be repealed. In short, the new law, make no mistake, is too broad. It can impact citizens, permanent residents, and foreign nationals guilty of no wrongdoing. This is striking. Applicants, their spouses, and children would have little, if any, options left under the IRPA. Generational impact. So recommendation 1 is a requirement for legislative clarity. We've heard a lot about it. The word sanction remains undefined, but it's also been divorced from grounds of violating human or international rights. It's now a standalone, undefined ground for inadmissibility, which currently exists in the IRPA. Why? Is this not the harm we are targeting? Bad actors in violation of human rights or international rights? Section 35.1 must be connected to human or international rights violators. Key terms like sanction and entity must be defined in the IRPA. This is all very important because subject matter experts in the sanctions regime, like Dr. Andrea Sharon, and a prior Senate study, raised several acute issues, too many to recite here, but to mention a few about sanctions: the need for parliamentary oversight, better coherence and compliance, timely and independent redress avenues, accountability, transparency, and other practical challenges. For example, Canada continued to leave sanctions in place against foreign states like Liberia and Sierra Leone long after the United Nations lifted them, a legal purgatory under Bill S-8. This committee should address that regime, and I understand it's going to study, before the passage of Bill S-8. Put plainly, individuals' lives could be significantly altered by a law that potentially should not apply to them. Equally troubling, it may not exclude some of the bad actors because the law becomes immersed in legislative ambiguity and applicatory limitations, resulting in procedural and fairness concerns possibly rising to the level of constitutional issues. Recommendation 2, legislative clarity is also required for the Citizenship Act and the Emergencies Act. That has not been discussed thus far. Canadians should not be at risk of losing their Canadian citizenship on a precarious legal foundation. Same for recommendation 3. With respect to dependence, IRPA cannot lose its jurisdictional integrity by being restricted in providing relief where justified in the confines of its own act. Ironically, in the sanction regime, there's legislated exemptions, but really none remain for those involved in navigating the IRPA. Recommendation 4 underscores the need for overbreadth and excluding those with no personal wrongdoing or any transgressions or any connection to transgressions. Recommendation 5, we rely on David Mattis's brief before Senate. Granting of refugee status should result in immediate delisting. Access to refugee status should be uniform in and outside of Canada. We propose calling David Mattis and Dr. Sharon to testify. It is critical we maintain the jurisdictional independence of the IRPA and its harmonious intersection with other domestic international legislation for the objects of the acts and the clear intention of Parliament to be realized. To get there, Bill S-8 needs further study and amending. Thank you.
The next round. Thank you.
Oh, sorry about that. Thank you. We next go to Mr. Oliphant. 4 minutes.
Thank you, Mr. Chair. I particularly want to ask Ms. Minimus and Mr. Bellissimo about your experience as legal advisors in removing people from our sanctions list. You both spoke extensively about the problems in the system, and I'm just wondering about your expertise in that area and your experience in the number of cases you've had of people you've removed or helped or been unsuccessful in removing from those lists.
I think I'll allow my colleague, Mr. Bellissimo, to
Mr. Chair, Mr. Bellissimo.
Would you like me to begin?
He's waiting.
Yes, of course.
Should I speak? Yep.
Yes, Mr. Bellissimo, please proceed.
Oh, sorry. Yeah, so thank you for the question. The reality is that immigration lawyers are not dealing with individuals that have been sanctioned because, as you can see from the testimony, it's just not come up in 20 years. The system is quite robust now, and the dangers of what I'm discussing is, you know, in the 26 years, in seeing what legislation falls for constitutional challenges or for other reasons and ends up getting struck down, is because what happens is there's almost an echo chamber. There's a lot of emotion, there's a lot of energy, and there's an issue that you can almost get into a situation where targeting the bad actors, which we all agree we want to eliminate, but by going so far, those bad actors suddenly have legal options available to them because the law is so broad and so vague, and suddenly the law...
Thank you, Mr. Chair. I'm going to begin on line with Mr. Bellissimo, and specifically to the fifth recommendation that you brought forward. I believe that was put forward by the CBA, specifically that states that a Canadian refugee determination, whether inland or abroad, should lead automatically to the deletion of the name of a person from all sanctions list. What I'm going to ask you to do is comment what you might feel the impact would be on irregular immigration into this country. Would that slow it? I mean, immigration is something that we all support around the table, but ordered immigration. Can you comment, please?
Thank you for the question. It's a recommendation actually made by Mr. David Mattis. The impact on irregular arrivals, given the amendments to the Safe Third Country Act, would now be minimal at best. I think the issue with the delisting is, even though there's access to refugee status, there is no access to any sort of status, be it temporary or permanent, until you're delisted. So those individuals remain in a state of legislative limbo, and that, practically speaking, would be very difficult moving forward. And I think it's a part of the bill that hasn't embraced the actual next step of what happens when someone is able to make a claim but not seek any sort of status while remaining in Canada. Thank you.
What I want to do is, the Canadian Bar Association flagged that the referenced country really does become too broad a net. That, in other words, we are struggling with it here. We look at what's happening with China. We look at the disinformation. We look at the foreign interference question. We don't want to say that Chinese are not admissible to Canada. So how do we balance and define that so that we do not, and I know you have to name people on a sanctions list, but how do people inadvertently not get into that particular trap because they come from a particular country, say like Belarus or like China or Russia, who may or may not be ordinary citizens, and who may have similar names, or who may have relationship to somebody that has nothing at all to do with government distinction and government deliberations. How do we do that? I've heard a lot of people suggest things. It's just somebody with a nice, clean recommendation. Go ahead.
Thank you. I think, and it's an excellent question, it has to be tied again to grounds of violating human or international rights. Any individual that is sanctioned, there has to be a direct link. It cannot be separated as a standalone sanction ground because of geographic location or country. I think that is a step backwards in the legislation that we currently have in place. And I would caution everyone to be careful moving forward on that basis, because it might be 3 steps backwards rather than a few steps forward.
So you are recommending that we define that a little bit better in the legislation?
Yes, that it remains currently a sanction is tied to grounds of violating human or international rights. For some reason in this bill, it's been divorced. It's been decoupled, as my friend said, from the Refugee Center. And I think that's risky in law in terms of enforcement.
Okay, well, thank you very much. And now people have talked a lot about redress. If your name is on a list and that you're inadvertently there and that you want to take the name off because you're John Smith and there are hundreds of John Smiths around the world and you just happen to be named John Smith. Now, the minister told us at the meeting that there were ways to redress that problem, that you could go to GAC, that you could get relief at the federal court, and that there is, for people who do not have money or the means with which to address those things, that there is money being put into legal aid to help them to have access to that kind of justice. Do you think that's sufficient? Do you think there is something else that can be done?
But just very quickly, I'll add, I think you need to leave safety valves in place where there are innocent individuals, should have more immediate redress within the IRPA, ministerial relief, access to the Immigration Division. I think those safety valves are important both for the constitutionality of the provisions and for ease of reference. Again, we want to get the bad